the next step in the conversation about the Supreme Court ruling that we heard some background on the other day. Yeah, and that was Bradley, I think, who was walking through that. And you will recall that we got to the point where the definition of RAPS came up, and we wanted to understand as we prepare to think more about what we might do moving ahead, what exactly are the required agricultural practices. We talk about them all the time. We have, I think, sort of maybe a vague or intuitive sense of what they are, but now it's come to a legal issue. We should probably be better informed. So we're going to hear from Ledge Counsel this morning, and then this afternoon, the agency is going to come in. And you can tell me if this is the correct way of thinking about it or framing it, Mike, but there's statute that addresses it. And then I think there is also rule that addresses it. And yeah.
Are you live right now?
Yes, we are.
Okay. So this is Mike O'Grady with Legislative Counsel. Yes, I'll work backwards. The required agricultural practices are currently rule, and they have been rule since they were first authorized in 1991. And that authorization is in statute. And for much of from 1991 to 2015, the directive for the practices, and I'm going to call them practices because between 1991 and 2015, they were the accepted agricultural practices, the AAPs. Then when you did what people call the State Clean Water Act in 2015, the Senate specifically changed accepted to required. But it was by rule since 1991. And I'll show you, I actually have the, enabling authority for that. Okay. So in 2015, you got very specific about what the RAPs needed to include. There were about 12 subdivisions that the RAPs needed to address as part of that State Clean Water Act. And each of those subdivisions has its own additional provisions underneath the rules as the Agency of Agriculture adopted them. So it's a long-standing requirement for the agency to have a rule defining the practices. First, they were accepted, then they were required. But the accepted term was something of a misnomer for several years because they were, even though they said accepted, they were actually required. And that created some confusion in the farming sector. So that's one of the reasons why it was changed to required in 2015, because it didn't make sense to the chair of Senate Natural at that time to have a rule that was required to say accepted. So that's why it was changed to required.
So, Mike, just to be clear, that this body directed AAFM to come up with the accepted, we'll call them RAP right now.
Right.
In rule.
In rule.
Uh-huh.
And that's, and I'll get into it in my presentation. That's something that I don't think the Supreme Court fully digested. When they looked at let's step back, and I'm sorry I didn't review Bradley's testimony to you, but the court implemented what's called a plain meaning interpretation, and courts are supposed to affect the legislative intent. That's their primary goal. And if they can do that just by reading the language and its plain meaning, they will do that instead of going and looking at legislative intent or statutory history or the scope of the regulation itself. So they made they based their decision largely on the fact that required agricultural practices as authorized in statute are for agricultural water quality. They didn't look at the rule itself, which is broader than just agricultural water quality. And they didn't treat the references to required agricultural practices as a reference to the rule. They treated it as a reference to what the agency was supposed to adopt. And I think if they had gone back and looked at the legislative history of the municipal exemption and of the accepted/required agricultural practices and the scope of the required agricultural practice, which they partly did, there's this really, I'm getting ahead of myself, but there's this really interesting reference to farm structures and how farm structures have been determined to be exempt from municipal regulation by a Vermont Supreme Court decision. But farm structures are regulated under the required agricultural practices. So I don't know if farm structures are subject to municipal regulation now, because the court said municipalities can only regulate those aspects of farming that are not agricultural water quality related as required agricultural practices. Well, the farm structures isn't water quality related. It's about building. It's about setbacks. What happens with that? I don't know. And maybe the agency can tell you more about that, because it's my understanding that they are trying to reach something of a legislative resolution of some of these questions and reinstating, at least in part, the exemption for farming, because municipalities, if they can't regulate water quality, they can regulate everything else: location, siting, setbacks, hours of operation, noise, odor, solid waste. That's what they have authority to do in their general enumerated powers in 24 VSA 2290, where they have a lot of authority. They can even regulate animals underneath that authority. So what do you want? What is your intent, right? Because remember, the courts are supposed to affect their primary goal is to affect legislative intent. I don't think that TAF decision affected your intent. I think that plain meaning analysis was either too limited or it was a results-based decision, because it was all around the exemption of cannabis cultivation from municipal regulation. I think you have to look at it. I'm not saying that the court did that, but I think that played into the court's analysis as to how they got to where they are, where they were here. So I read the decision. I'm like, this is a plain language decision, and it doesn't understand the regulatory structure. And I'll point out one of the ways that it doesn't understand the current regulatory structure.
Just one more thing while we're in 1991. So it really began over water, right? The
exemption started before the accepted agricultural practice. The exemption was in law before you directed the agency to adopt the accepted agricultural practices.
Really?
And that's something that the court didn't address. The court said in 1991 there was the accepted agricultural practice and they were for water too. And so it has always been about water. Well, like, hey, but the municipal zoning exemption was in 1987. And it said, according to accepted agricultural practices and silvicultural practices, that were adopted by the Commissioner of Agriculture or the Commissioner of Forests and Parks.
So the exemption is 1987.
Not 1987. And so it didn't get tied to the rule adopted by the agency until 2003.
So I just wondered, at what point on the agency of ag side did they sort of come to a conclusion that we need to define what farming is? You know, that's whether it's 15 goats or 14 goats.
Yes, and I want to talk about that because I think that's one of the parts of the regulatory structure that the Taft decision didn't understand. It said it would be anomalous to interpret the RAPs as applying or farming practices or farming in general to apply to only 15 or more goats when it should apply to all goats. Well, you made that decision in 2015 or 2016 to say, no, not every ownership of an animal is farming. And I have a little headline from 2009. There was the Barry homeowner who had 3 roosters and 4 chickens, and the roosters were boisterous. And the town wanted to regulate them, and the homeowner said, no, I'm farming. I'm selling my eggs. And the agency was getting a lot of those requests from towns. Is this farming? The agency didn't want to do that. The agency doesn't want to go to a backyard in Burlington and say you're farming. Right. And so they set those thresholds for what is farming. And the Taft issue really kind of that property owner, that farmer plus cannabis cultivator, he really understood what he was doing.
He did a lot, or
Yeah.
what he thought a lot.
Yeah. And he manipulated it to his advantage. But, you know, that's like criticizing people for taking tax deductions. I mean, yeah, maybe billionaires shouldn't take tax deduction, but the law allows it. They are allowed to do it. You might not like it, but it's allowed. And people didn't like what he was doing, but it was allowed. So I'm like a little afield now.
Well, you want to, should we bring you back to the presentation?
So let's talk about the required agriculture practice. As I stated, they are required by statute, and they shall be management standards to be followed by all persons engaged in farming in the state. And they shall address activities that have potential for causing agricultural pollutants to enter the groundwater and waters of the state. And they shall promote and encourage practices for farmers in preventing agricultural pollutants from entering the groundwater and waters of the state when engaged in animal waste management and disposal, etc. And as I said before, they have been around. This is a 1991 law, Act number 261. And you can see that they are directed again by rule to adopt and implement and enforce agricultural land use practices in order to reduce the amount of agricultural pollutants entering the waters. And they were called, one category would be accepted agricultural practices, and one would be best management practices. Now, then the accepted agricultural practices were deemed to be the required practices, and the best management practices were things that the secretary could require you to do if necessary to meet water quality requirements. So accepted was everybody BMPs, something that the secretary could require for individual property owners, farmers, et cetera.
Just a quick note, Dave, on what we were talking about neonics. That's a really interesting line there that it says the secretary can require BMPs.
Yeah, yeah, relevant, right, relevant to that
Right. Yeah.
topical. This is, we're looking at something printed in 1991.
Yeah.
Right, and that's when the original practices came.
This is the initial enabling authority for what became the RAP.
And then you mentioned a moment ago that the exemption existed even earlier.
So this is the statute from 1992, and you will see 4495, no plan or bylaw adopted under this chapter shall restrict accepted agricultural, silvicultural practices as defined by the Commissioner of Agriculture or the Commissioner of Forest and Parks. And you will see that it was added in 1987. So this predated that 1991 law. But then in 2015, there was Act number 64, often commonly referred to as the State Clean Water Act, which I don't like, but that's what people do. And you will see that the required agricultural practice, that term was added in 2015, and it replaced accepted agricultural practices. And you can see it kind of divvied up that subsection from how it was drafted in 1991, and it broke out what a required agricultural practice is. And you don't see it on the slide, but there was now a subdivision C, which is the best management practices. So directive for land use practices that will identify and implement non-point sources. The first is going to be required agricultural practices, and then there's best management practices. So this is where the terminology of RAPs initiated. This is where it was born. And it was partly because of the kind of intuitive, like, why should accepted agricultural practices why required accepted agricultural practices not be referred to as required?
So the practices had been required all
Yes,
along.
yes.
It's just renaming the
Right.
category or the group. Okay.
And remember that there are additional requirements for medium farms and large farms that go beyond the required agricultural practices. So the agency regulates water quality in many ways other than the required agricultural practices.
Representative Nelson.
Thank you. Would accepted and required means we have to do it. Accepted would be you can milk cows on a tie stall, or you can milk cows on a milking pad. You can make dry hay, or you can chop silage.
Right, but remember, this is a rule.
Yeah.
This was a rule, and what you had to do under that rule, what was mandatory under the rule was in the rule. You could parse the plain meaning of what a required agricultural practice is versus an accepted agricultural practice versus just an agricultural land management practice. And that's kind of what the Taft Court did. They kind of was like, well, we're not going to look at the reference to required agricultural practices as a universe defined by a rule. We're going to look at the plain meaning of what that means and how the statute is saying that it just is about non-point source water pollution. And so if you define it as the rule that the exemption that municipalities shall not regulate required agricultural practices, it's everything in that rule, which includes farm structures. But that's not what the court said.
But how could the court go against the 4495 from 1987. When it said that farming was exempt from zoning and whatnot. Because it was changed after.
It was changed after, and I don't know if I have the change in my slides. But let me get to that in a minute.
It's fine.
So-
Representative O'Brien had a question.
Yeah, just quickly, at this point, since you were here, on the silviculture side, why didn't they accept RAPs? Did they, at that same time, did they develop the AMPs? I mean, it's interesting that in the beginning, right, they're tied together as far as exemption goes.
No, you didn't get to the specifics about the silvicultural exemption until it was the big year, 2017 or 2018. It's in that time frame when Commissioner Snyder came forward with just a total proposal to restructure the laws regarding harvesting. That's when they came forward with a proposal for required notice of harvest, required trip tickets, et cetera. And the trip tickets and harvest notification failed, but the right to forest did not fail. And that was amended in 4413. Because 4495 became 4413 in 2003. And that's when the subsection was reorganized, and then it was reorganized again in 2017, maybe, when the right to forest came in. And the right to forest is different. It says the municipality shall not regulate by bylaw accepted silvicultural practices or forestry operations. So it has that, not just the practices or what's defined in the practices, which are water quality, but also how forestry operation is defined in statute, which is pretty much most everything that you can think of as a forestry operation. So it's kind of curious now that the municipality can regulate farming except for water quality, but they can't regulate forestry operations. It's just curious, as that's not how it was intended in 1987. Remember, in 1987, they were together as exempt from municipal regulation.
You just showed us there.
Yeah. So, but what do the RAPs include? So remember, I said in 2015, you got really specific about what they were required to include. You said they had to have requirements for prohibiting or stacking, piling manure. They had to have setbacks for that. You had to have standards for nutrient management, had to have standards for construction and management of barnyards and waste management system. You had to have soil loss requirements, the T requirements. You needed to have standards for buffer zones. You needed to have flood hazard area requirements. You needed to have standards for exclusion of livestock and standards for cover cropping. And it goes on, not very much further, but the General Assembly was very, very specific about what those RAPs were to include. And they did. And the agency went through a pretty long and, it was a very involved process because there were so many people that were interested, and they adopted the RAPs. And this is just a screenshot of their table of contents. And so they have requirements for agricultural water quality training because there are requirements that farmers get trained in agricultural water quality requirements. So that's part of the rule. They have requirements or a prohibition on direct discharges from a farm because that's part of the statute. And so that's in the rule. They have requirements about storage of ag waste and agricultural impacts. They have, that's directed in the statute. They had to like have concrete pads or be set back, or the silos, those for your inputs, be set back. And so that's in the rule. There's requirements for nutrient management planning, which is how you deal with your manure and your inputs and how you apply them to your field according to site-specific conditions. That's in the rule. There's soil health management and cover crop requirements, the T requirement and how you do cover crop. That's in the rule. Manure and waste application, when you can apply manure, where you can apply manure, because there's some setbacks for where you apply manure. You don't apply manure right next to a public water system, for example. There's buffer zone.
Excuse me, Mike. I'm wondering, Patricia, if you can you minimize or eliminate that view of our room? We don't need to see that, and it's blocking the,
Okay, look.
I don't know if you're-
It's here, thanks, sorry. Yeah,
if we have the power to do that.
let's see, I think there's a couple of options, so that one doesn't help, let's see, nope. I just have to cycle through them and see what's
You went
gonna
back, it
work.
was interesting, yeah, because you had the same view.
Yeah, well, we have, so that's where we started, right? So I'm sorry about this, but shared content view, what would that look like? No? To speak, no. No. No.
Okay, well,
Ah.
we can,
Yeah,
we can,
yeah, I'm so sorry about that. Oh, wait, wait.
At least to the
Hang on.
right.
Yes, I
Section and
I
slide.
think I can just move it to the top. Let's see if that works. No.
Or is it actually on Mike's screen?
Maybe that's it, yeah. Thank you.
Brian, you get it next slide.
IT is my future.
Okay. So there's buffer zone requirements, the setback between the surface water and your cropland, or a ditch and cropland. There's animal mortality management requirements, like how you deal with your mortalities, how you compost those mortalities, how you compost imported food processing residuals, which is not a water quality requirement, right? That's how you deal with the waste, the compost food residuals that come in, and how you manage that, because there was literally something called the composting wars about how to allow for composting on farms. That's part of the RAPs, and that's not a water quality requirement. That's a composting / solid waste requirement.
so under, as, to the extent that you understand it anyway, under the court's ruling, do municipalities now have the ability to regulate the composting?
I don't know. I don't know, and I'll show you why I don't know, because because it really depends on if they meant that municipalities can't regulate required agricultural practices, if they meant the rule and the confines of the rule, or the plain meaning of that term, the agricultural land management practices for non-point source pollution. And I say I don't know because, all right, let me just preface that. The RAPs are more than water. The RAPs are about construction of farm structures and setbacks for farm structures, and how to comply to the best of the farm's ability with the municipal setback, as approved by the Secretary of Agriculture, not as approved by your municipality. And there's a variance process in the RAPs for how you go about not complying with the municipal setbacks. Again, in the RAPs, it's not the municipality that governs the variance process, it's the secretary that does, and that's in the RAPs. And in Taft, they said 4413D1A, which is the municipal exemption, does not prohibit all municipal regulation of farming. if that farming is subject to the RAP's rules and the landowner's duck raising operation is not exempt from municipal zoning solely because his activities are subject to the RAP's rule. Rather, 4413 D1A prohibits municipal regulation of required agricultural practices. All right, we're like, it's not the rule, it's that term, or the agricultural land management standards intended to protect Vermont's waters established by the RAP rules and imposed on certain. So composting's not something that's there to protect Vermont's waters. So is that still exempt?
On that slide, Michael. So this is the decision.
This is an excerpt from that decision. So let's look at 4413 because it says a bylaw under this chapter, this is the municipal authority 24 VSA 4813. A bylaw shall not regulate required agricultural practices, including the construction of farm structures, as those practices are defined by the Secretary of Agriculture. So required agricultural practices, we looked at that enabling authority. It did say it was about controlling non-point source pollution, water pollution, etc. But the rule and this exemption say that required agricultural practices include construction of farm structures. And farm structure is buildings, enclosures, fence, raising horticultural or agronomic plants, or carrying out other practices associated with accepted agricultural farming practices, including a silo, but it excludes a dwelling, which makes sense.
Representative Nelson.
So this is all well and good. You know, we can put up our barns and put our animals in it and contain our waste.
But if you're driving your tractor after 8 o'clock at night in the
Or
summertime,
after 5 o'clock.
Right.
Whatever they decide, or before 5 o'clock, 7 o'clock in the morning, feeding their cows.
the existing municipal noise ordinance might now apply to you.
Exactly. So this is, and again, it gets to accepted agricultural practices. Now, if you're a good neighbor and you have a loud exhaust on your vacuum pump and you milk cows pretty much around the clock, and someone says, Nelson, can you muffle that better? You ought to muffle it better. And we have. But you know, that's being a good neighbor and working with your neighbors. But I can't control when I have to put in feed. You have to put in feed when the sun shines and.
Or harvest your corn.
Yeah, exactly.
You know, if freeze is coming and it's October or late September and you're like, you gotta work through the night.
So this is the crux of the issue is getting back that the accepted practices are exempt.
And I also want to make the point that last year you strengthened the right to farm. And you were clear that you wanted farmers to have additional protections and additional activities to be protected under that nuisance protection. This subverts that because why do you even bring a nuisance claim? You just go to your municipality and say to your municipality, they're violating the noise ordinance. They're violating the traffic requirements. You know, like,
You need to change the zoning laws to protect us.
you need to cite them away.
Yes.
So
And
that's-
even if you owe $10 million to the bank, you need to put them out of business.
Representative Lipton.
I'm inquiring about a path to a solution to this. Would this committee draft, work on an amendment to the bill or the rules or whatever that would clarify and protect the intent of the original act, which might then null and void this decision.
Oh, definitely.
That's my question.
Definitely. You have the authority, especially in with decisions of this kind, where you don't believe they met the legislative intent to clarify what the legislative intent is and to effectively override the court's decision. But there's an entire body of advocates out there that are probably important to you, and I mean your municipalities, who are looking at this and saying, well, what are we going to get out of this? And I respect that. I respect that. You know, it's something that they have the opportunity right now to say the things that they don't like should be addressed. And that I think is part of this dynamic right now.
After we have heard from Ledge Council and the agency later this afternoon, we're going to take some testimony from farmers with their perspective on how we could fix this. Probably their perspective is closely aligned with what you're imagining we could do. But then we're also going to hear from the League of Cities and Towns, which has, represents the municipalities and has a different, perspective. And the agency has yet a third perspective. So this is a political question. This is going to be an interesting exercise in the way democracy works, because there are different interests. And we as representatives have constituents who will have possibly different interests. But I think we're hearing that the intent of the legislation, which hasn't been questioned for 25 or 35 years or whatever it's been, seems to be different from what the court's reading of the language.
Well, let's talk about that. So we were talking about how farm structures are regulated under the RAPs. I think we've already went over that, but the RAPs are used throughout statute to refer to the activity that the agency will regulate as farming. Because this is the headline I referred to, the Barrytown Roosters were an issue, and the minimum animal thresholds or criteria for application of the RAPs are intentional. The court said that would have been anomalous. The court said it was anomalous to think that farming was defined as something where 1 to 14 goats is not farming, but 15 or more is farming. That wasn't anomalous. That was fully intentional. It was fully intentional. It's done only in the RAPs, but it was done with the consent of the legislature. The agency brought the RAPs to you with that proposal and told you why and told you how they were spending resources, because the agency has to respond to every complaint. The agency has to respond in some way to every complaint. And what they were doing, they were sending people out to people's backyards to see if their roosters were farming. Like, that's not what I think you want them to be doing. And that's why those thresholds were set. And it wasn't anomalous. It was intentional.
So the Supreme Court essentially said, like, one chicken is farming, one tomato plant is farming. Otherwise,
I don't know.
like you're saying, you don't need a bright line. This is farming, this is not.
I don't know what their intent was, the court's intent was, and the scope of what this decision will mean. I really, it's. I don't know if you remember, this came out on the last day of the session. I was running around like a chicken with my head cut off, right? And I was like, you gotta do something. And I'm like, because I'm concerned about what this means. I don't know the scope of how this will be applied. If you're a municipality with issues, you now have authority to address those issues. And I think you might even have authority to allow things that aren't allowed. Like what kind of farm structures get built. And, you know, I don't know. I don't know. I wish I could tell you. And let's look at that, like,
Representative O'Brien?
So potentially might, like the manure spreading ban. This is saying like a municipality couldn't.
they can't regulate the manure spreading ban.
It can't enforce like, oh, Richard's spreading on Christmas, so we're gonna shut him down, but.
But they can regulate when he's operating or the noise from his tractors when he is operating.
If they, like ordinance wise, right? If they just do a complete ban, like no spreading manure in our town?
I don't think they could do that because that's allowed under both statute and rule.
Okay.
But I think they could get at that through certain ways.
Okay, Representative Bartholomew?
Very early on, you gave a list of things that included things like setbacks, and I think you said it was stuff that municipalities could regulate. Do you, very, like, one of the early things, first thing you.
Sure, under general,
Was that after this ruling or before the ruling?
that's
Did I understand it correctly, that it was municipalities can regulate all that stuff?
they can't regulate it. Before the ruling, they could not regulate that for farming. Subject to the RAPs,
So you're saying they can do that?
they can do that now.
Can you give me that list again? Setback was one, there was a whole bunch of stuff.
Title or municipality powers.
It's old. But in 1969 or 70, legislature passed the Interim Planning and Development Act, which enabled and empowered municipalities to adopt land use regulations, zoning districts, which included road frontage setbacks, side setbacks, rear setback. I was alive and active.
Tony got shot at.
From both sides, right?
Oh, yeah.
Off earlier.
So this is what the authority under zoning includes: location, size, height, building, bulk, yards, courts, setbacks, density of buildings, off-street parking, loading facilities, traffic, noise, lighting, landscaping, and screening requirements. But municipal bylaws also include anything that's authorized under 24 VSA 2291. That includes things such as the operation and use of vehicles, location, installation, repair of utility poles, wires, water pipes, erection of signs or displays, keeping of dogs. Find one that's what constitutes a public nuisance. These are now getting very specific. Parking lots, screening requirements. So that's what their authority is.
Isn't before it is, that was your point earlier.
Right, because 4413 says a municipal bylaw, whether it's a zoning bylaw or another enumerated authorized bylaw, shall not regulate required agricultural practices. And the court said, well, required agricultural practices are only those water quality control practices, not the. No, shoot, where is it? I think I lost a slide somewhere. Oh, no, here it is. So in the decision, they said that they previously had examined the question of whether farm structures were exempt from municipal regulation, and they said that they were. And we further acknowledge that this conclusion was bolstered by the fact that 4413 reflects recognition by the legislator that in order to survive, Vermont farms must enjoy the freedom to diversify and engage in reasonable agricultural activities. We did not, however, address the meaning of required agricultural practices in that prior Supreme Court decision. And our interpretation of the term farm structures, a term specifically defined by the legislature, has no bearing on how the secretary has defined required agricultural practices. Except the rule that's called required agricultural practices has requirements for farm structures in it. So how does that have no bearing? So I don't know if farm structures regulated under the RAPs are exempt, but the rest of the RAPs are not, except maybe composting's not, is still exempt. Does the RAP variance process still apply? I don't know. The court didn't answer these questions. How this is gonna be implemented is either gonna take years more of litigation or some legislation. And I also want to point out that the RAPs are used to define the scope of other laws. They define whether water discharge law, ANR's water discharge law applies to a farm or not. They determine, whether the phosphorus fertilizer ban applies to farms or not. They determine whether or not municipal stormwater fees apply to farms or not. There's more. So if this is only about agricultural land use management practices and not what is an activity regulated by them. And I will say in the municipalities shall not charge an impervious service fee or other stormwater fee on property regulated under the required agricultural practices. So not just I think that's type of language, that type of conditioning is potential for you to resolve this issue. And so, but I don't know where the league falls on that. The league is probably going to be very involved. So the General Assembly enacted the RAP requirements to address water quality. The court is right about that, but they have been used to define the scope of farming and activities more broadly than just water quality. And the ag exemption for municipal regulation has existed since 1987. It was recodified and restructured it was first restructured in 2003 and then in 2023. And Mike, is this consistent with your intent? So I don't opine on intent because I'm not a legislator and different legislators have different intents. But I don't know what this decision means for the regulation of farming.
Is there any significance either in the court's reading of the law or in how we should be thinking about the solution here, resolution to capitalizing those three words?
Yes, and I have gone back and forth with the editors about this for years. And I was like kicking myself yesterday about why didn't we capitalize that? Why aren't they capitalized? So to denote that it's something specific, something of a certain universe. And I thought about that. I mean, would that have made a difference? I don't know. Or fully defining required agricultural practices by the Agency of Agricultural's adopted rules known as X. You know, being and everything within it. Or every practice or every person subject to that. And I think I didn't draft, I mean, I've been here for a long time, but I didn't draft the 1987 and or the 2003 laws. But I thought they were artfully done. But apparently they gave the courts opportunity to interpret.
Could you go back to slide 10? It's the current existing 24 VSA. Yeah. When we were looking at this yesterday or day before yesterday, I just was wondering about so a bylaw shall not regulate required agricultural practices, et cetera, as defined by the secretary. And naively, I'm sitting here wondering, why can't the secretary then just define more explicitly what those practices are to address and solve the problem?
Because the court says the RAPs are standards for causing agricultural pollutants to enter the groundwater and the waters of the state. And so that's the difference, that kind of distinction of treating the RAPs as a rule, a universe defined by what the agency adopted, or interpreting it to mean what the plain meaning of this is. And only about water pollution control. And I think the agency could try what you just proposed. They could, but it would probably at some point inspire litigation as to whether or not, you know, this is not like constitutional law. You need where just the fact that it violates the Constitution gives someone, most people, some sort of standing to sue. You need to have a right at interest in order to sue for application of this law or non-application of this law. And so just if you passed something or the agency did what you proposed, Chair, somebody would have to have a particularized interest that was affected by what the agency adopted. And that takes time. That takes time in most instances to arise.
Mhm.
And so
Representative O'Brien.
Mike, is there case law on the whole sort of farming threshold, you know, that this farmer with 12 goats, you know, ran into ordinance problems because of that threshold?
not that I know of.
There are, I anecdotally, I feel like there are, but some towns regulate roosters, for example, that here you can't have three roosters
Yeah.
but if you have enough roosters,
Or ducks.
let's use roosters as, but yes, it could be ducks. But there, so we talked about the 14 versus 15 goats.
Right.
There's a similar number. Maybe you know how many roosters you can have or how many chickens, but
The number for chickens is pretty high from my recollection. It's 100 laying hens, 50 geese, 50 turkeys, 100 ducks.
so if you had 99 ducks currently, or I mean, last year, before the court ruled, the town could regulate
The
your.
town could regulate that.
So presumably then, in the case, there were more than 90, there were 100 or more ducks living in that.
I have not talked to anybody at the agency who actually went and made the determination, but when you look at the background documents on it, the property owner has a determination by the secretary that he constituted farming.
Oh, there are other ways though to, right, you don't.
Like money, yeah.
It could
Money.
be income. Yeah.
So something like the rooster thing, is it under noise ordinance, like a sub-chapter of noise ordinance?
Where towns do
Yeah.
regulate that.
A town probably could either regulate the number of roosters that you own or even prohibit it underneath the threshold prior to this decision. Or yeah, say that roosters are a noise violation. I will note that the General Assembly state statutes, one of the things you generally don't regulate is noise. You generally leave that to municipalities. Now, like wind turbines and some other things, you've gotten into that, but noise is usually a municipal authority.
Representative Nelson.
Yeah. Certain. As much as we like to. Certain things go on in certain places where they shouldn't go on. But the LFO permit, MFO permit, that all stemmed from back when the chicken farm went in up in. You know.
Partly, yeah.
Partly. Before then, everybody was happy, everybody was doing their thing.
In Highgate, that one?
Yeah, yeah. And, you know, this stems from a duck and, marijuana grow operation. I don't know where it was in Essex, sounds like it was right in a.
And that's. I mean, it's like an endless kind of circle here. It's like, would this have been an issue if the Cannabis Control Board had denied his application for a license? Probably not. But did the Cannabis Control Board have authority to deny his license? They say no. And so it's a little bit of a wonder wheel here.
A farm in Orleans. Closer to my home.
Senator Bartholomew.
I want to make sure that I understand correctly though. So these thresholds that are set, if you're below the threshold, you're not farming.
You're not farming.
And the required agriculture practices do not apply to you, right?
That's right. Well, I don't know anymore. I don't know. If the required agricultural practices don't define the universe of what's farming, do you need to set back your composting pile from your site or surface water? Do you need to control water that comes off of your impervious surface? I don't know.
Yeah, and then I get to the question that I have is that are there farming operations are there loopholes where the reps should apply, but they don't? Do we have loopholes in this?
There's probably people that would argue that there are certain instances that should apply, but I can't think of any particular case.
Sounds like it's pretty clearly defined, or used to be clearly defined.
It used to be.
Okay. Thank you.
So it's confusing. It's a little hard for me to get my head around just because of
Hard for me to get.
ambiguities, yeah, that seem to be introduced. But what we know is that there has been a decision that overturned one instance in one community. Are you aware of any other, Mike, has there been any other?
Not that I'm aware of. And this is a question for the league. I don't know who's coming in from the league. Is it Ted or is it someone else?
I'm not sure. We haven't actually established that.
I mean, one of the questions to them is, are municipalities exercising their authority under this decision? And to what extent? If I were the league, I would probably advise municipalities to tread a little carefully. Because if they start doing things like prohibiting certain practices that are necessary for the operation of a farm, especially a long-standing farm, then you'll raise the ire of the farming community, and that's something that is I recommend you avoid.
Like I was thinking, what Richard and you were just talking about was part of the problem with this, the bit about cannabis growing that we put into law. I think it was from Bobby Starr, right?
That John, this is Representative O'Brien, that you don't get to undoing that unless you undo the RAPs and the exemption under the RAPs. Because the cannabis language was that they will receive the same exemption as afforded to those activities regulated under the required agricultural practices. And so the court, in order to say municipality gets to regulate that cannabis cultivation, they have to say the municipality gets to regulate the farming under the. That's why I think that it might have been a results-based decision.
Yeah. And that was the duck part. It's like, look, I'm farming, I'm under the RAPs, and so I get the benefits of a small cannabis grow that the legislature.
I think if you could have looked at it either way, he was a small cannabis grow and you said he gets the same exemption as he did as a farmer. And therefore he was exempt either way.
Right.
And now the court said, no, he's not exempt either way.
Do you know, what was this a unanimous court decision?
That's a great question because it's not signed and I can't find it on the Vermont Supreme Court website. I'm getting it off of one of the legal documents providers. I don't know. I can't tell you who it all was.
What, when you say you can't find it?
It's not there.
And should it be there?
It should. I mean, I can double check. I haven't looked in a couple of months actually, so I can check again.
Does the Supreme Court here work like the federal one where, they're dissenting opinions sometimes?
Yes. There wasn't in this opinion.
Okay, we know that much anyway. There was no.
What, at least of what was published, there was not a dissent.
Right. Any other questions while we have Mike on this issue? Uh, the the definitions of agriculture may come up again in this conversation, so we talked about the number of animals that qualifies you, but then also your income qualifies you as farming. And the size of your operation, acreage,
Acreage
yeah,
plays into it as well.
yeah.
And remember that that's only one way you define farming in statute,
One of 24 ways or whatever.
20.
Yeah.
One of 20 ways that farming is defined.
But is it relevant to this discussion? That way of defining?
Yes, I think it is very much relevant to this discussion because you want to define the universe that's legitimately farming versus the universe that is, I own a cow and 10 chickens.
Yeah.
It's not legitimately, well, that will be up to you. That will be up to you if that's legitimate.
We've done a lot of work on accessory on-farm businesses, so they're connected to the reps too, right?
Yes.
Yeah.
They're connected more to Act 250 than they are to the reps. Because farming under Act 250 is not defined by the animals or your income. It's defined by if you're engaged in one of the listed practices. And so I honestly don't think accessory on farm is going to be affected that much. But that'd be a question for the agency, what they think. I'm just curious about how the agency would propose to resolve the issue.
They are working on that. I think, and I think we'll hear from them next week.
So you've already passed the threshold for individual content or individual requests for a bill. Your content is now the 15th. But I don't know what vehicle you would use for this.
So, good question. Do we have the authority though to do a committee bill?
You do until in the Senate, it's the end of January. I think for you, it's the end of February, but I will double check that.
Okay. I always wonder about the title and whether we can do a committee bill in a title that isn't our title, Title VI or.
That's a question for the clerk. I think this is very much related to agriculture, and it may involve amending Title VI and the authority for the RAPs. So I think, depending on what the resolution is, I think you can definitely argue germaneness. I mean, you amended the right to farm in Title 12, which is judiciary.
Mm-hmm.
You have jurisdiction over Title 9 and parts of Title 20. So
It's 24, right?
24.
Do you know, just as an aside, speaking of deadlines, the question has come up about the December 1st deadline for requesting bills. That was the deadline. And yesterday or the day before, we passed a rule, we approved a change to the rules that I understand takes effect next, looking ahead. But the question has come up as to whether there may be some leeway on this year for bills that were introduced after that, or requested rather, after that.
It was my understanding that the Rules Committee wasn't going to provide leeway for the bills and requested, but would for content and bill introduction.
Okay.
But I can double check on that for you.
Not for content, that deadline also passed already before the resolution was adopted. So it's only introduction.
That's not my understanding.
Well, that's what. That's
I know you're on the Rules Committee.
That's what Bryn said at the meeting.
What Brent told me.
Okay.
What's the intent?
Yeah.
I will ask because
Well, that's what I said on the floor yesterday.
I am drafting based on the content standard being the 15th.
Why don't we take a break?
Right, yeah.
So we can go off live. That means, and yeah, so we'll be back at 11 with Bradley to walk us through the list of reports that were